So assuming you do have to comply in your job postings, the law requires that you state the minimum and maximum salary or hourly wage for the position. When originally passed, the law talked about salaries, and there was a question of what happens for employees who aren't paid on a salary basis but are paid on an hourly basis. It's clear that the city was only looking to cover compensation, not to distinguish salary from hourly wage positions. So now any form of compensation theoretically has to be identified with a caveat that I'll mention. The range may extend from the lowest to highest salary wage or salary or wage the employer in good faith believes at the time of the posting it would pay for the job. Now, the only real clarification beyond saying it has to be a good faith belief is that you can't just say either the minimum or the maximum. You cannot say we will pay at least $50,000 a year, and you can't say we will pay up to $100,000 a year. There has to be a lower and upper range. Now, how large that range can be and what would be considered good faith is open-ended and is subject to potentially future litigation over whether a given range was reasonable under the circumstances. So the law just requires the minimum salary or hourly wage and the maximum salary or hourly wage. There's no requirement to identify overtime rates or even whether overtime is applicable or any other forms of compensation or benefits.